Ladies and gentlemen, it's always my pleasure to address this gathering. I've been here on a number of occasions. Tonight I have a subject which was commissioned by Diane, and to me it's dry as eating gypsum board. But it may be interesting to you because it does have some serious consequences. The relationship between administrative agencies and tyranny. To begin with anything of this nature, you have to start with some definitions. Administrative agencies are governmental establishments that are composed of unelected professional career bureaucrats who serve for indefinite periods of time. The mandates of these agencies cover specific fields of interest and supposed expertise of those bureaucrats. Now, although in traditional understanding an agent always has and is accountable to a principal, a modern administrative agency is considered in some sense independent of the legislative, executive, and judicial branches of the general government. This is particularly peculiar in that the Constitution provides for not a single administrative agency. Instead, every administrative agency is the creature of Congress, yet every administrative agency is supposedly somehow independent of Congress. Now, proponents of administrative agencies in the administrative state will contend that these agencies, largely independent of the legislative, executive, and judicial branches, must exist so that decisions crucial to the regulation of economic and social affairs in this country can be made by experts on a supposedly non-political basis. How do they operate? The administrative agencies generally dispose of some combination of quasi-legislative, quasi-executive, and quasi-judicial authority. They promulgate regulations, guidelines, and directives for the interpretation of particular statutes which have created them. That's their quasi-legislative function. They investigate and prosecute violations of the enabling statutes and the regulations they have enacted. That's the quasi-executive function. And in some instances, they even adjudicate these violations, and that's the quasi-judicial function. Today, many, if not most, of the important substantive decisions as to what basic policies are to be adopted in Washington are made on a day-to-day basis by administrative agencies and not really by the legislative, executive, and judicial branches of the government at all. Power, in fact, has become so centralized in dozens of these interlocking agencies as to make the agencies a veritable administrative state unto itself. I could give you a lot of examples. A prime example is the Federal Trade Commission. Now, that's a very apt example because most people associate the rise of the administrative state and administrative agencies with the administrations of Franklin D. Roosevelt in the 1930s and 1940s. The FTC, however, was created nearly a generation earlier with the administration of Woodrow Wilson in 1914. And of course, Roosevelt was an Assistant Secretary of the Navy in the Wilson administration, and he learned the lessons of centralized government in that particular school. Now, the Federal Trade Commission is one that the Supreme Court has talked about at some length on various occasions. 1935, for example, a case called Humphrey's Executor versus the United States. You're all familiar with that. I don't have to go into detail. But the Supreme Court did observe that the history of the Federal Trade Commission, quote, demonstrates the congressional intent to create a body of experts who shall gain experience by length of service. A body which shall be independent of executive authority and free to exercise its judgment without the leave or hindrance of any other official or any department of the government. Now, that statement neatly encapsulates the essence of these agencies: expertise, independence, duration of service. Now, in that same case, the Supreme Court went on to describe the FTC as an administrative body created by Congress to carry into effect legislative policies embodied in the statute in accordance with the legislative side. I can go on and on with this. This gibberish. The Commission acts in part quasi-legislatively and in part quasi-judicially. To the extent that it exercises any executive functions, as distinguished from executive power in the constitutional sense, it does so in discharge of its quasi-legislative and quasi-judicial powers as an agency of the legislative or judicial branches of the government. Now, the reason I quoted that is because notice the mysterious aspect of what they're saying. To the extent that the FTC exercises any executive functions as distinguished from executive power in the constitutional sense, it does so in discharge of quasi-legislative or quasi-judicial power. But what are executive functions distinguished from executive power in the constitutional sense? Where does the Constitution provide for or permit the exercise of executive functions separate from executive power? Indeed, how logically can functions be separated from powers that relate to them? And how constitutionally can an agency of the legislative or judicial departments of the government execute executive functions any more than can the legislative or judicial departments of the government itself? Well, the court didn't say, for the obvious reason there is no answer to those questions. Right? Now, most people here today, I suppose, can list many other alphabet agencies with structures, functions, and breadths of mandates similar to the FTC, Securities and Exchange Commission, Food and Drug Administration, Environmental Protection Agency, Internal Revenue Service, Federal Reserve System. We could go on and on. The question is, to what extent are these independent administrative agencies consistent with the Constitution? Well, analysis of the propriety of these agencies must begin with a precept that was long recognized in Anglo-American law far earlier than anyone ever thought of the Constitution of the United States. And that principle is that a delegated power cannot be delegated. John Locke, probably most of you are familiar with his second treatise of government, section 141, he says, rather absolutely, the legislative cannot transfer the power of making laws to any other hands. For it being but a delegated power from the people, they who have it cannot pass it over to others. The power of the legislative being derived from the people by a positive voluntary grant and institution can be no other than what that positive grant conveyed, which being only to make laws and not to make legislators, the legislative can have no power to transfer that authority of making laws or place it in any other hands. Pretty straightforward. So in light of this precept, which underlies the whole body of Anglo-American legislative law, any delegation of Congress's legislative powers to some independent administrative agency must be highly suspect. Well, more than that, the Constitution plainly outlaws every delegation by Congress of congressional authority, because it mandates in Article 1, Section 1, that all legislative powers herein granted shall be vested in a Congress of the United States. And even the Supreme Court, 1913, case of Ettor versus City of Tacoma, recognized that a right that is vested cannot be defeated by subsequent legislation. The only legislative powers which the Constitution grants are those which it grants to Congress. And Congress can exercise only those legislative powers which have been granted by the Constitution. Now, circle there, right? The Constitution delegates to Congress no general power of delegation of legislative authority. In fact, I don't think the word delegation appears in the Constitution at all. Therefore, Congress cannot, by subsequent legislation, that is, by the exercise of any of its powers, which are all legislative powers, by constitutional definition, it cannot transfer to anyone else a power constitutionally vested in itself, QED, end of discussion. And even the Supreme Court, in one of its rare lucid moments, in Panama Refining Company versus Ryan in 1935, and I do recommend anyone who wants to read a really good opinion of the Supreme Court, that's one of them, all right? It held on the basis of Article 1, Section 1, that Congress manifestly is not permitted to abdicate or to transfer to others the essential legislative functions with which it is vested. That would seem to close the door. The Constitution says that, the Supreme Court says, but listen, unfortunately, even in this decision, the court qualified its statement with the weasel word, essential. Right? It's not, Congress is not authorized to transfer its essential legislative functions. A qualification which, of course, does not appear anywhere in the Constitution. As far as the Constitution is concerned, all of Congress's legislative functions are essential, or the Constitution would not include them. Right? And I might carry on with this to point out that this same concept of vested powers occurs in Article 2 with respect to the President, and Article 3 with respect to the judiciary, and it has never been held by anyone that the President could delegate his presidential authority to some kind of administrative agency, or the judiciary could do this either. Well, where did this concept arise? It actually didn't arise with Roosevelt and didn't arise with Wilson. Notwithstanding what the Constitution says, in 1825, the Supreme Court, and once again we come to the usual suspect in this one, right? We come back to the Supreme Court in the case called Wayman versus Southern. proffered a very loose theory, and that is, and I quote, "Congress may certainly delegate to others powers which the legislature could rightfully exercise itself. The line has not been exactly drawn which separates those important subjects, which must be entirely regulated by the legislature itself, from those of less interest, in which a general provision may be made, and power given to those who are to act under such general provisions to fill up the details." All right? This little bit of fuzzy language is the basis of the whole system. Think about that for a second. Now, according to this decision, filling up the details can justify a delegation because it does not constitute the performance in the constitutional sense of the legislative function. One is entitled to ask, however, what sort of function in the constitutional sense does such a delegation perform if it is not a legislative function? After all, it is a delegation of legislative authority from a legislature. And by what criteria can those important subjects, which must be entirely regulated by Congress, be separated from those subjects of less interest, authority over which Congress may supposedly delegate to someone else to fill up the details? Because once again, if you read the Constitution as opposed to the opinions of the Supreme Court, you find no answers to those questions. Or you find the opposite answer, in fact. Moreover, the Constitution neither specifies exactly what are always nothing but details, nor provides a rational means for determining what the supposed details might be in some specific instance. What might constitute mere details in someone's speculative estimation could turn out in practice to be very numerous, complex, and of weighty consequence, depending on the subject matter. For as the old saw has it, the devil is in the details. So it should hardly be surprising that, contrary to what the Supreme Court may have imagined when it cavalierly created this exception to the non-delegation doctrine for mere details, administrative agencies over the decades since then have been armed with the authority to interpret the statutes which created them, to promulgate rules, regulations, guidelines, and other directives, to implement those statutes, to execute the statutes and regulations by means of investigations and prosecutions, and even to adjudicate in non-judicial tribunals purported violations of the statutes and regulations, all of which would seem to go beyond mere details. Now, proponents of the administrative state invariably invoke necessity. What do we know about necessity? That's the last argument of tyrants, right? The last argument of tyrants is always necessity. They say, we need necessity for this. And once again, we come to the Supreme Court, that famous case, Sunshine Anthracite Coal Company versus Adkins. You're all familiar with that. The Supreme Court rationalized sweeping delegations of congressional authority in the 1930s on the theory that they were necessary in order that the exercise of legislative power does not become a futility. And then in a later case, 1941, the court claimed that in an increasingly complex society, Congress obviously could not perform its functions if it were obliged to find all the facts subsidiary to the basic conclusions which define its legislative policy. The Constitution, viewed as a continuously operative charter of government, is not to be interpreted as demanding the impossible or the impractical. Continuously operative charter of government. We have another term for that in the law. What is that? The living Constitution, right? The thing that changes chameleon-like from day to day as political background changes. Now, statements such as these paint a rather defamatory portrait of the Founding Fathers. Apparently, when the framers granted only certain explicit powers to Congress, they were too dull to realize that they were demanding the impossible or the impractical of Congress. Apparently, they did not provide explicitly for delegations of legislative authority because they were too myopic to foresee that such delegations would be necessary in order that the execution of legislative power did not become a futility. So they needed the Supreme Court to interpolate the notion into the Constitution much later on in order to correct these childish errors. Worse yet, such statements from the Supreme Court amount to excuses for unlimited government, because they presume that every possible subject in an increasingly complex society lies within Congress's jurisdiction. That is, that the supposed complexity of society, which is largely a matter of opinion in any event, rather than the specific terms of the Constitution, determine the extent of Congress's power. But why should anyone ever presume that the supposedly complex economic and social problems which politicians try to involve the government in really fall within Congress's constitutional functions? Constitution grants Congress no general power in so many words to legislate about what some people may consider to be economic and social problems, even if those problems are increasingly complex. Furthermore, America has been an increasingly complex society from the beginning. This didn't start in 1930 or 1940, right? So the particularly increasing complexity of modern times can no more expand congressional power than did the ever-increasing complexity of the past. If some power to deal with increasing complexity through delegation of legislative authority exists today in the Constitution, it existed when this country began. And if not there then, it must be absent now. Moreover, if Congress cannot marshal what the Supreme Court denoted as all the facts subsidiary to the basic conclusions which support the defined legislative policy, must not the proper conclusion be that such a policy lacks a sufficient basis in fact to be legislated in the first place? Right? If they can't figure out what to do, then how can they do it? Another one of these circular problems. If it is impossible, if it is impracticable for Congress to enact specific legislation on some subject, must not the proper conclusion be that such a subject is simply beyond the actual constitutional authority of Congress? And in both cases, must not the inevitable inference be that a purported delegation by Congress to an administrative agency of a power which Congress itself is incapable of exercising is not a delegation of an existing congressional power at all, but instead is an attempt by Congress to create an entirely new power for that agency? Well, I don't have to answer those questions because they're self-evident. Congress, of course, is the source of the administrative state. There's always some statute lurking in the background that has created one of these agencies. And the executive branch, to a certain extent, is a major participant in it, as many of these agencies operate, at least titularly, within the executive branch. But what about the judiciary? Well, in the course of the steady and systematic development of the administrative state, a familiar pattern has emerged. And you see this in other areas. First, the Supreme Court has injected a false principle into constitutional jurisprudence. In this case, the loose concept of filling in the details. That's the first thing. They blunder. They make a big mistake. Second, over the years, various beneficiaries of that false principle have acted upon it, of course, greatly expanding its reach and its effect step by step, presumably far beyond what the Supreme Court may ever have imagined originally would happen. And then third, rather than admitting its initial error and correcting the first problem, the Supreme Court in later years attempts to mitigate the damage that the false principle causes by somehow regulating the application and use of that principle to minimize its misuse. That's the old concept of closing the barn door after the horse has escaped. Right? Thus, in various of its opinions, the court has evinced the position that although Congress is manifestly not permitted to abdicate or to transfer to others the essential legislative function which is vested, a delegation is supposedly constitutional where Congress has stated the legislative objective, has prescribed the method for achieving it, and has laid down standards to guide the administrative action. And it's very interesting because once again, when you read these opinions, the Supreme Court is using non-constitutional terms as the measure of constitutional authority. Instead of declaring delegations to be always invalid on the basis of a fixed constitutional rule with a basis in the words of the Constitution, the court decides whether a delegation is valid or invalid based on its interpretation and application of terms which are not to be found in the Constitution at all. When the court refers to intelligible principles, by what reading of the Constitution are such principles to be determined to be intelligible? When the court goes on about standards of legal obligation, which Congress may have set out in a statute, what constitutional standards are to be applied? Well, once again, these are questions that never find an answer. The court makes this up as it goes along. What are the principles if they're not constitutional? Well, they're political and invented by the judiciary. Well, actually, there was a case that attempted to lay down a rule, American Power and Light Company versus SEC, 1946. Congress reiterates all of these ideas about legislative standards and principles and so forth and so on, and says that the remedy, the ultimate remedy, is that private rights That is, the rights of individuals who are affected by what these administrative agencies do. Private rights are protected by access to the courts to test the application of the policy in the light of the various legislative declarations of standards and so forth. So, the rule here, according to the judiciary, is that Congress is to set up standards based on intelligible principles so that the agencies can determine what are the mere details in the legislation, and then, if something goes wrong, the victims of this are to go into the courts and have the courts vindicate them in some sort of judicial proceeding. The problem in practice, however, is the determination of whether all of these principles are sufficiently intelligible to operate as standards will always be made by the agencies in the first place. These questions don't come before the courts in the first place. The judiciary becomes involved only when the agency's determination somehow becomes the subject of litigation. And how often is that? Well, if you practice in this area, you understand that litigation will not always, and indeed not even usually, follow an agency's actions. In how many cases has the Supreme Court, let's take that as the classic example, in how many cases has the Supreme Court actually enforced these various standards one way or the other? In how many cases have the courts in general been called upon to do so? In fact, in how many situations could they be called upon to do so, given the amount of work that these agencies do from day to day? Very little of their activity could possibly come before the courts, and if only because most people who are affected by the agency's actions really can't afford to litigate the matters. So worse yet, when the litigation does ensue, the courts have adopted a rule by which they defer to the agency's supposed expertise. We come back to that point, right? The agencies are experts. We're just the judiciary. We don't know anything about this, so we have to give them, in essence, the benefit of the doubt. We defer to their expertise. Whether this is a matter of an agency's interpretation of a statute or of an agency's finding of fact. So when the agencies act quasi-legislatively, the courts say, well, you have more knowledge about this statute than we do, so we're going to accept your interpretation unless it's so ridiculous that no reasoning person would accept it. And when you act quasi-judicially in an administrative hearing of some kind, we're going to accept your interpretation of the facts unless, once again, it's beyond the pale of reasonableness. So what's the overall effect of this? Well, Justice White observed in a case called INS versus Chaga in 1983, not that long ago, that, and I quote, "In practice, restrictions on the scope of power that could be delegated diminished and all but disappeared during the 1930s. So the effect of it is, yes, they've set up this house of cards of judicial oversight, but the reality of it is that its effectiveness is essentially nil. And you might ask the question, why did that happen? The same reason has happened in many other areas, where the court has invented these houses of cards where it pretends to protect rights of various kinds, and then in the real world it doesn't. Because the justices are in favor of this type of a setup. They want an administrative state in this country. But they want to give you, the average American, the impression that they are in control of it and somehow you are protected by the judiciary when in fact you are not. And I don't think that there's any lawyer who has ever practiced in this field or in the constitutional field that in a moment of lucidity and honesty would not agree with that point. Most of them will disagree for another reason, that they want to keep their careers going, but if they're honest about it, they'll tell you that. Now actually, the administrative state amounts to far more and is far more dangerous than what you'd call the typical ideological nostrums of politicians and judges. This is because it is not merely a happenstance composite of details cobbled together on a hit-and-run basis from odd congressional delegations of authority over the years. Rather, it is an intentional and systematic transmogrification of the form of government which the Constitution prescribes. Its purpose and effect have always been to defeat the Constitution in particular and popular representative government in detail. Now, one might say, well, that's a serious charge. But it's a charge easy enough to prove. Let's go back to the original founding document, Declaration of Independence. Declaration of Independence characterized the misbehavior of King George III as, quote, a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over the American colonies. And among the acts which may define a tyrant, the Declaration excoriated the king for, quote, altering fundamentally the forms of our government. Well, when the Declaration was published in 1776, the universal understanding was, I said earlier, a delegated power cannot be delegated. And just 12 years later, in 1788, the Constitution applied this principle threefold in the articles which provide that all legislative power shall be vested in Congress and all executive power in the President and all judicial power in the judiciary. So, if we look at the administrative agencies in general, and certainly at the administrative state, we would say, well, this system has altered fundamentally the forms of our government. And in fact, in a case decided in 1952, Justice Robert Jackson, now he was the prosecutor in Nuremberg, Attorney General of the United States, Justice of the Supreme Court, under Roosevelt, prosecutor of the Nazi criminals in Nuremberg. Justice Robert Jackson candidly informed Americans that administrative agencies, quote, have become a veritable fourth branch of the government which has deranged our three-branch legal theories. But given that our three-branch legal theories perfectly reflect the very structure of the Constitution based on the plainest text on the face of the document, and therefore are facts, not theories, precisely how is a fourth branch of government, and especially a fourth branch of government capable of deranging the Constitution, legally possible? Once again, Justice Jackson didn't tell us. Well, because the administrative state does in effect constitute a fourth branch of government, an amendment of the Constitution was necessary to allow for it. No such amendment has ever been ratified or even proposed. Therefore, having by everyone's admission altered fundamentally the forms of our government, and having done so unlawfully, the administrative state must constitute, in the words of the Declaration of Independence, an injury and usurpation having in direct object the establishment of absolute tyranny over this country, QED. Right? You don't have to be a justice of the Supreme Court to recognize that. Is this description too harsh? Well, not at all. The characterization of the administrative state as a form of tyranny is perfectly accurate. Tyranny can be defined in a number of ways. Everyone here, I suppose, should be familiar with what James Madison wrote in the Federalist number 47. Quote, no political truth is certainly of greater intrinsic value or is stamped with the authority of more enlightened patrons of liberty than that the accumulation of all powers, legislative, executive, and judiciary in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. Well, in contrast to the form of government established by the Constitution, which carefully separates the legislative from the executive from the judicial powers in different hands, so as to create checks and balances against misuses of public authority, administrative agencies combine all three of these powers in the very same hands, eliminating checks and balances and therefore facilitating, if not encouraging, abuses and misuses. Thus, even if administrative agencies attempted in good faith to promote their arguably benign conceptions of the public interest, they would always remain tyrannical in principle, under the principle that Madison wrote in the Federalist Papers. And an apparently benevolent tyrant is no less a tyrant than an obviously malevolent one. Moreover, being tyrannical in principle, administrative agencies are capable of turning from benevolence to malevolence simply by changing their policies from day to day. Nothing more needs to be done. The very same bureaucratic personnel, facilities, machinery, and powers are available and capable of being applied to malign ends. More than that, administrative agencies have not only absorbed in tyrannical form many of the mere legislative, executive, and judicial powers that we, the people, originally delegated to the general government, but in addition, they have arrogated to themselves something far beyond those powers, namely a large measure of the people's fundamental sovereign authority itself. Now recall the supposed reason for setting up administrative agencies in the first place. According to the proponents of the administrative state, America needs this fourth branch of government, which is largely independent of Congress. The agencies are to be non-political so that they can exercise their expertise without undue influence and interference arising out of irrelevant political pressure. But because the purpose and effect of creating independent and non-political agencies is to insulate the matters assigned to those agencies from effective political control by Congress, and because Congress itself is subject to political control by we the people, supposedly, in the final analysis, the purpose and effect of creating independent and non-political administrative agencies is to remove these matters from significant control by we the people too. Or should I say, from significant control by we the people especially. We are the targets of this, you and I. Now this is hardly accidental. It's not an unintended consequence of the creation and operation of these agencies. It's the essence of the process. After all, by hypothesis, the bureaucrats who staff the agencies are selected precisely because of their supposed abilities to deal with these special matters assigned to them as the result of their highly specialized education and training and experience, etc. By hypothesis, these professional experts always know better than ordinary laymen. Therefore, they know when to disregard the mundane desires of the people and to act contrary to and even in defiance of those desires. For in contrast to experts who can be expected to remain steadfast in pursuit of their thoroughly thought out policies over the years, the people are mercurial in temperament. They're devoid of the necessary technical knowledge. And they're prone to fits of political enthusiasm or hysteria. Right? We know the way people are. Chronic interference by the people through regular elected representatives who attempt to inject the people's ever-changing and often simplistic ideas into the workings of the agencies can only interfere and predictably frustrate the experts who are attempting to plan on a long-term basis. In an increasingly complex society, this sort of amateurism simply cannot be tolerated. So it must be understood that Congress's responsibility is to enact statutes which delegate vast areas of authority to administrative agencies, and then to see to it that the agencies always receive adequate perpetual funding. And we, the people's function, is simply to elect dummy representatives who mechanically accomplish these tasks. Thus, the purpose of the modern political process of representative government and of we, the people's participation in that process is to conduct a charade. In the guise of representative government, we create, empower, and equip the agencies with whatever the agencies want, and otherwise we stay out of the experts' way in the determination and enforcement of public policy. We, the people, are never, by any means, actually to control the agencies. Rather, the agencies are, by whatever means they can muster, to control the people. For the people's good, of course. You have to understand that. Yeah. Well, in their harping on the value of delegating governmental authority to independent, non-political administrative agencies, the partisans of the administrative state tend to overlook several points. First, all of the general government's branches and the position of every public official are inherently political, simply because those branches and officials are the creatures of and are entirely dependent upon and subservient to the people's political sovereignty. Therefore, they are always required to perform all of their functions according, in the final analysis, to political supervision and criteria, which can be enforced in one way or another by the people, either at the polls or perhaps through the process of impeachment or whatever. Criminal prosecution, that's my favorite. We won't talk about it. Second, by delegating in the Constitution certain powers to Congress, which is, of course, the quintessentially political branch of the general government, we, the people, demonstrated that they desired those powers to be exercised according to political criteria. And that exercise should be subject to political checks and balances of representative government, which the Constitution also requires. And in contrast to this, well, the independent, non-political administrative agencies must be, or they must aspire to be, and they certainly act as if they were, independent of we, the people's political sovereignty within those areas in which the agencies operate. Well, sovereignty can never be in abeyance. Someone always has to exercise it. If, whether directly or through representatives elected on a regular basis or in some other manner, we, the people, do not exercise their sovereignty over those areas of governmental activity assigned to various agencies, then the agencies must exercise sovereignty there. Well, needless to say, this result contradicts the essence not only of the Constitution, but of the Declaration of Independence. Well, so much for the definition of tyranny applicable to administrative agencies in principle. Tyranny also has a very practical definition that's applicable to them. Going back to Locke, section 199 of his second treatise, he defined tyranny as the exercise of power beyond right, which no body can have a right to. And this is the making use of the power anyone has in his hands, not for the good of those who are under it, but for his own private special advantage. And in section 201 of that same work, Locke explained that it is a mistake to think this fault is proper only to monarchies. Other forms of government are liable to it. For wherever the power that is put in any hands for the government of the people and the preservation of their properties is applied to other ends, and made use to impoverish, harass, or subdue them to the arbitrary and irregular commands of those that have it, there it presently becomes tyranny, whether those that use it are one or many. Later on, in Federalist Number 10, very famous passage, James Madison described a faction as comprising, quote, a number of citizens, whether amounting to a majority or minority of the whole, who are united and actuated by some common impulse of passion or of interest, adverse to the rights of other citizens or to the permanent and aggregate interests of the community. So you combine those two. Public officials and public institutions must be condemned as tyrannical when in fact they impoverish, harass, or subdue the people to arbitrary and irregular commands in order to serve the interests of factions adverse to the rights of other citizens or to the permanent and aggregate interests of the community. And these factions may consist of rogue public officials or of citizens who collude with such officials in order to obtain special benefits or advantages to the detriment of the community as a whole. Sounds like a description of Washington, D.C. right now. Well, especially in its reference to the purposes of providing for the common defense and promoting the general welfare, the Constitution, in its preamble, emphasizes precisely that the general government is powerless to expend and extend special favors to factions, whether in individual cases or by creating institutions that are set up for that particular purpose. And so important is this principle that the Constitution repeats it in Article 1, Section 8, Clause 1, namely, Congress shall have the power to lay and collect taxes, to pay the debts and provide for the common defense and general welfare of the United States, and for nothing else. All right? Thus, the Constitution denies Congress the authority either to raise or spend money for purposes which are adverse to the permanent and aggregate interests of the community. So Congress cannot finance agencies which themselves act as or which promote the special interests of factions. And if Congress cannot finance the operations of such agencies, it can hardly claim a power to create them in the first place. Seems like this is another one of those constitutional circles. Now, on the one hand, administrative agencies would qualify as factions when they were truly independent, not only of Congress and we the people, but of all other private special interest groups. And when they exercised this independence in the personal interests of the expert professional bureaucrats who ran them, but in a manner adverse to the permanent and aggregate interests of the community. You think there are agencies that do that today? Try the Environmental Protection Agency. Try the IRS. You want to run down some lists? We can spend an hour listing these agencies that fall into that category. In that case, if, as is usually the situation, the bureaucrats were putting into practice some economic or political ideology that called for government planning of society, usually that's their rationale, when we're planning something for you. The administrative state could be likened to a particularly malignant form of socialism. That's one possibility. That's not representative Republican government, but it's what is there. If, on the other hand, the agencies serve various private factions, such as large corporate interests, the administrative state could be likened to a form of corporatism or fascism in the Italian sense. In this particular case, an agency might be created for the very purpose of advancing the parochial interests of some particular businesses in certain segments of the economy. Think of the Federal Reserve Board and the Federal Reserve Act of 1913. Why was that created? For the banking interests. And they said it at the time. Right? They were very upfront, as it were, with that. Or the National Recovery Administration under the National Industrial Recovery Act of 1913. That was set up with respect to various parts of American industry in general. Cartelization of American industry as Roosevelt's first attempt to defeat the Depression. So we have seen this in American law. The National Industrial Recovery Act is gone, but the Federal Reserve Act is still with us. Or an agency originally created in order to regulate some segment of the economy in the public interest might, in the course of time, be politically captured. That's the word. The agency would be captured by the businesses it was supposed to supervise, and thereafter would regulate those businesses in the business special interest, quite in disregard of the public interest. And I think one would conclude the Food and Drug Administration, probably a good example of that, where, whatever the purity of the origins of that agency, it has subsequently been captured by the big pharmaceutical companies. Right? Now, of course, none of this should be surprising to students of criminal politics. Because all governments which the people do not strictly control tend to factionalism in purpose and then to tyranny in form. Why? Factions always promote tyranny because tyranny provides the surest support for factionalism. Tyrants will always support factionalism under the principle of divide and rule. These things work together like the iron hand in the iron glove. Well, the consequences of Congress's creation of the administrative state, with all of these delegations to agencies of great swaths of legislative power, I would say in principle are rather frightening, and probably they will become more frightening in practice. We go back to Locke, section 227 of the second treatise. When either the legislature is changed or the legislators act contrary to the end for which they were constituted, those who are guilty of rebellion. For if anyone by force takes away the established legislator of any society, and the laws made by them pursuant to their trust, he thereby takes away the umpirage which everyone had consented to for a peaceable decision of all their controversies, and a bar to the state of war amongst them. They who remove or change the legislative take away this decisive power, which nobody can have but by the appointment and consent of the people, and so destroying the authority which the people did and nobody else can set up, and introducing a power which the people hath not authorized, they actually introduce a state of war, which is that of force without authority. Right. That's the ultimate consequence of the breakdown of the forms, which the Declaration of Independence told us, right, when the forms of government were changed illegally. This may be a state of Cold War at the present time, but it's a state of war nonetheless, and I would suggest it's going to become quite a bit warmer when the Federal Reserve System melts down in the not-so-distant future. We see one of the effects of one of the major agencies on the entire country. Well, what's the final word here? I would say it's really simple. No possibility of compromise exists in this situation. Neither the Constitution nor the Declaration of Independence can coexist with the administrative state. But whether we the people will recognize this antagonism, and more importantly, will steel themselves to take the necessary corrective steps, still remains to be seen. Thank you, ladies and gentlemen.